Hello, and welcome to the Arbitration Conversation. So in this arbitration conversation, we are going to talk with an expert in arbitration from Venezuela. And we're going to talk about corruption and how that can impact arbitration, practically speaking. And it's really an important issue that is often not discussed, but today we're going to talk about it. So here with me today, I have Professor Fernando Sanquírico. He is a professor of civil law and history of Roman law at Monteavila University, Andrés Bello, Catholic University, and Central University of Venezuela. He also teaches in a center with advanced arbitration studies. And in fact, I'm very happy to say that he is going to be working on a collaborative project with the University of Missouri Center for the Study of Dispute Resolution, which is a really cool and exciting new collaboration. So thank you so much for coming to join us on the arbitration conversation.
Thank you, Amy. It's really an honor to be here today with you.
Well, this will be really important. So, we think, well, it's arbitration, right? It's arbitration. It's all going to be ethical. We're not going to worry about corruption. How does corruption come into play when we talk about arbitration?
Well, corruption, if you go through some of the international conventions on corruption, some of them avoid giving a exact definition of corruption. Okay, but what they do is they define corruption by defining some types of acts that can be ascertained as corruption. For example, bribery, trading in influence, embezzlement, and other acts that can be used as corruption. And sometimes corruption, when we think about corruption, we think about governmental involvement. But sometimes with these corporate structures that are very big, and inside corporate and private entities, you can also find corruption. For example, you can find a corporate officer who has the authority to enter into some contracts, who can accept bribery within the company to enter into corruption. To enter into that business, by accepting bribery. So it's not only governmental, and these kind of acts affect business, and some big companies cannot enter into does not accept entering into this kind of business by accepting corruption. Some scholars have tried to define corruption by saying that it is a disease of our society, and other kind of definitions that are more sociological or philosophical than legal. But when it comes to arbitration, we have had some approaches when an arbitrator, and not only arbitrators, we lawyers, practicing lawyers, professors, Center of Dispute Resolutions, for example, ICC, PCA, and so many others have encountered corruption within the knowledge of their cases. So what to do? And for example, what to do? This question comes with or very connected with arbitrability. So is corruption arbitrable? Can we as arbitrators can decide a case that we know by ourselves, or one of the parties comes and brings an argument into the proceeding that is involved with arbitration? So the arbitrators faces a very challenging question, which is, first, can I arbitrate, or can I accept my jurisdiction to the corruption issue that is being brought here to the arbitration? But second, and most important, given the fact that arbitrators have the obligation to try to render a enforceable award, and most of the times in international arbitrations, the award is not going to be enforced in the place of the arbitration. So is public policy of the placement of arbitration going to accept my understanding or my decision on corruption in this issue? So these are big questions, you know. It's not that you're deciding upon, you know, the breach of a contract.
No,
You're
right. And under the New York Convention, you're right, you could run into sort of, is it an enforceable award, right? Because you could say under public policy that perhaps it's not, right? So how do you get around that? I mean, it's interesting as you're talking, I actually had a case once as a lawyer representing a party where we wanted to bring a claim of corruption in the arbitration in a construction deal. And you run into these issues. Is it going to even make for an enforceable award? How do you come out on that? What is your analysis?
Yeah, well, my analysis comes first studying some cases. Uh, you know, not every award is public. So the investigation in arbitration, as you know, and I know every listener of this podcast knows, it's sometimes hard when it comes to the study of case law. But we have some of them, you know, because of the publication that ICC makes of some of their awards and other cases. And for example, we have a very early ICC award in 1963 of Professor Lagergren, which is one of the cornerstones of these issues in corruption and arbitration, you know. And what he did in back then in 1963, as I told you, is that he said he couldn't uphold arbitration, jurisdiction, because he said that public policy could not accept that parties can use a international adjudication process such as an arbitration when parties are bringing some corruption uh, things into the arbitration, you know. So this it might comes to the idea that in fact arbitrators doesn't have jurisdiction, as Professor Lagergren said back then, again in 1963. But that made the community of arbitration think, you know, because one thing is not having jurisdiction, and other thing is to start thinking to what extent the jurisdiction goes when it comes to arbitration. So most of, and my findings are that arbitrators have jurisdiction, but the jurisdiction ends where the arbitrator decides upon the application of the arbitration in the business or in the contract, in the commercial agreement that is being decided. For example, if I had to decide here in Venezuela the civil system law, uh, I had to say, for example, you know, the contract existed because of corruption. So there is a lack of free consent in our system. So the contract must be declared null. So I'm deciding inside the contract a decision that is, you know, contractual decision, but for an external factor that is implied in the business that is at hand. So corruption is impacting the decision, and I'm not deciding whether the corruption is a criminal, has criminal effects or administrative effects. The corruption has civil effects, and the decision which comes to the corruption and it's embedded in the jurisdiction is to adjudicate the civil or commercial effects that corruption has into the business contract.
I would agree with that analysis, actually, you know, as a contracts professor myself. Yeah, the contract law issues I think would be arbitrable, but you're right, the criminal issues would not be, right? I mean, those are still open to be brought to a court of law.
Exactly. But here we have some other, you know, some other things that we have to think about when it comes to corruption. For example, standard of proof, you know, because some, you know, when I would say that today, most of the tribunals upholds jurisdiction, and let's be clear, thinking about the enforcement of the award. For example, if we know beforehand that our decision it's going to be, the award is going to be enforced in Pakistan. Maybe we cannot have jurisdiction because public policy in Pakistan doesn't allow the arbitrators to adjudicate corruption related issues into arbitration, you know. So, and we have the Hopco versus Wapad decision of the court in Pakistan. So that says if you're adjudicating arbitration, corruption within arbitration, you cannot adjudicate it. You have to take it into the courts. So, you know, it's a challenge that we arbitrators face. Maybe the award can be enforced somewhere else, but, you know, it's something to have in mind. But the standard of proof here, when it comes, if the arbitration panel decides to uphold jurisdiction, some arbitrators have decided to you know, make the standard of proof very high. And we have an arbitration, an exit arbitration. I have it around here, that it was EDF services versus Romania, which in my belief, they made a big mistake, because they said, and I agree with this particular thing that they say, that proving corruption is very hard, and sometimes it's barely impossible. That being said, the same arbitration panel, tribunal, in the same paragraph said, however, we need a very high standard of proof to adjudicate our corruption. So you're admitting in the same paragraph of the award that although it is very hard to prove, and they are aware of that, you know, hard proving thing of corruption, you know, but hey, come on, I know it's hard, but you know, you have to do the best of your abilities to prove it here. So I think sometimes proving or you know, taking the standard of proof to a higher level, it's not the way. I think, in my belief, that the same standard of proof for any other you know, allegation in the arbitration proceeding must be used. But and I believe, that's my belief. However, most of the arbitral tribunals have used the red flag standard of proof, and since 1982. So now you can see in ICC the award, the award in the case 3916 of ICC. They started using the red flags standard of proof. And what is the red flag standard of proof? They have some checks that we have to make. For example, the time of the negotiations, the clarity of the business, the exorbitant prices of the business, the high commissions that may be paid for the business, the lack of experience of the company that is conducted the business. So if you're going to review these kind of things, you have to go check in, and maybe and that's the actual, you know, usage of the standard of proof in corruption here in arbitration. So if you check these red flags, maybe you can end and have a decision that corruption is, you know, was a irrelevant fact in the process or in the commercial business, and then you can adjudicate the effects of corruption into the arbitration. But there is another issue that we need to have in mind, which is, and here it's a very delicate thing when we arbitrators face corruption challenges in arbitration, and that is, what if the tribunal finds that there is a corruption, or even though the party doesn't bring the corruption allegations into a proceeding, what if the tribunal or the Secretary General of the Center of Dispute Resolution finds there is a corruption thing inside the business? should the tribunal or the arbitrators or the secretary general or any of the administrative persons that are involved in the arbitration must inform the national authorities. Because, for example, here in Venezuela, our legislation doesn't oblige us to go to the authorities to make to get them aware of criminal offenses. But there are some other countries that that oblige any person who is aware of a criminal offense, if they encounter a criminal offense. So if the lex arbitri, for example, finds that there is a criminal offense, the arbitrators find that are bound to the lex arbitri find that there is a criminal offense, a corruption here. Does they have to inform the national authorities of that country that there is corruption? That is something to think about. I haven't reached to a conclusion on that point. It's a very delicate point.
These are all really interesting issues. I guess it's to be continued in terms of further analysis, but it's really important questions, and hearing your analysis is really helpful to a lot of people who perhaps have not even thought about it, right? So I really think this adds a lot to the conversation. So it's really interesting stuff. So I'm very thankful for your analysis. Thank you.
No, thank you, Amy.
Have a great.
You too. Thank you very much. If I'm available for you, and thank you very much for the opportunity.
Oh, absolutely. Thank you.